We have now gone over 3 chapters on wills. The first, chapter 3, considered the problem of establishing the authenticity of a will, or whether or not a revocation of a will was proper. The second of these wills chapters, chapter 4, considered the problem of establishing the voluntariness of a will, or the revocation of a will. Chapter 5 considers how wills are constructed or interpreted. It delves into questions about what meaning should be attributed to words. And in doing so, it looks at really 2 primary questions. This chapter asks, how should a court deal with ambiguous or mistaken language? And it also looks at how courts should apply a will to changed circumstances that can arise after the time that the will is drafted or executed and prior to the testator's death. We begin with Section A, which looks at mistaken or ambiguous language in wills and how such language should be interpreted. Courts vary in how they treat mistaken or ambiguous language in wills. Some courts apply the plain meaning and the no reformation rule. You can think of this rule as being the strictest interpretation. The plain meaning and no reformation rule are exemplified by Sanderson v. Norcross, where the court states that courts have no power to reform wills. Mistakes of testators cannot be corrected. Omissions cannot be supplied. Language cannot be modified to meet unforeseen changes in conditions. The only means for ascertaining the intent of the testator are the words written and the acts done by him. When possible, courts prefer to take the plain meaning of the words written in the wills, as can be exemplified in the next case, Mahoney v. Granger. In Mahoney v. Granger, the testator, Helen Sullivan, sent for an attorney to make her a will. She told the attorney she had 25 first cousins and she wanted them to take her property equally. So the attorney drafted the will, devising that the residue of her property go to, quote, my heirs at law living at the time of my decease, absolutely to be divided among them equally, share and share alike. Well, after the testator died, it turns out that she had only one heir, a maternal aunt, who was her next of kin. You see, the aunt trumped the cousins because for the collaterals, the applicable intestacy statute was based on degree of kinship. And the aunt was related in the 3rd degree, whereas the cousins were related in the 4th degree. Well, the cousins petitioned, and the court refused to admit extrinsic evidence in the form of the lawyer's testimony that the words heirs at law, the testator meant that the words heirs at law would mean her cousins. In the court's view, the term heirs at law was not ambiguous. There was no latent ambiguity. And so the court instructed that her property be given to the aunt. So again, to summarize the plain meaning rule, if the language in the will is unambiguous, evidence is not admissible to show that the testator made a mistake in describing the beneficiary or the property that was to be the subject of the gift. And again, this is the strictest way to interpret a will. The following case, in re Estate of Cole, demonstrates the battle that courts have had with traditional ways to deal with ambiguity versus a more modern interpretation. And in this case, the courts went with a more modern interpretation. However, it is a good case to also examine the differences between the traditional and the modern interpretation. So in re Estate of Cole, just a few days before Ruth Cole passed away, she executed a will that devised to her friend, Vida Vining, the sum of $200,000. However, in the writing of the will, in parentheses, the numerical number, as you can see, that was written out was $25,000. So this ambiguity or mistake is obvious. So the question really was what to do about it. Well, traditional law distinguishes between patent and latent ambiguities. But this court decided to do away with this distinction and instead to allow admissible evidence to allow extrinsic evidence to resolve the ambiguity. So, but what is the difference between patent and latent ambiguity? Well, patent ambiguity is the ambiguity that is apparent from the face of the will. Latent ambiguity, on the other hand, is apparent only when the will is examined in light of extrinsic evidence. Now, under under traditional law, only when you have a latent ambiguity would you be able to bring in extrinsic evidence of the actual intent. So with patent ambiguity, extrinsic evidence would not be admissible to resolve the ambiguity, and the bequest would fail. There are different types of latent ambiguities. Equivocation is when two or more persons or things fit the description exactly. Personal usage is if the testator habitually used a term in an idiosyncratic manner, then the way the term is used is generally understood. Then there could be a no exact fit and latent ambiguity in which a description in a will does not exactly fit any person or thing. But again, the main thing to remember here is that with traditional law, there is a distinction between these two types of ambiguities. And under traditional law, extrinsic evidence is only admissible if there is a latent ambiguity and not a patent ambiguity. Moreover, in re Estate of Cole, you will notice that the modern courts are increasingly inclined to admit extrinsic evidence to resolve both patent and latent ambiguities. Now, the book goes through two additional cases in an effort to demonstrate that regardless of the traditional or the modern rules that only apply to ambiguities and not to mistakes, courts will still try to circumvent the rules in order to correct even mistakes, despite the law not changing. So for your purposes, for the purposes of the exam, you can just skip Arnheiter and Arnheiter, as well as the next, which is in re Gibbs Estate. Now, it is worth looking at the UPC rule for Reformation to correct mistakes. Unlike the traditional no reformation rule that does not allow courts to change the terms of a will, the UPC 2008 does allow for the reformation to correct mistakes. It says the court may reform the terms of the governing instrument, even if ambiguous, to conform the terms to the transfer's intention if it is proved by clear and convincing evidence what the transfer's intention was, and that the terms of the governing instrument were affected by a mistake of fact or law, whether in expression or inducement. Again, please go ahead and skip In re Estate of Duke as well. I fear that it will cause more confusion than necessary for our purpose. For those of you that have read through the cases and are trying to place them on a continuum in your mind, I'm going to go ahead and put this slide in so that you can understand where they all fit. So the no reformation rule for mistakes says that no extrinsic evidence is allowed and no reformation is permitted, and that was demonstrated by the Mahoney case. Then the two cases after Arnheider and Estate of Gibbs that I asked that you skip, again, this was just the author's way of showing that in reality, even if a court has no power to reform, sometimes they do it anyway. So this is good for you to file away in your practical knowledge bank, but for our purposes, for the exam purposes or bar exam purposes, you won't need to remember this. But you do need to remember that the UPC does allow for open reformation, and extrinsic evidence is permitted to help with that reformation. For those of you that may not remember the clear and convincing evidence standard from property, here it is reprinted. It is a higher standard of proof that imposes a greater risk of erroneous factual determination on the party opposing the reformation. We're now going to move on to what happens if a beneficiary dies before a testator. So what happens if somebody whose name is in the will passes away before the testator does? The default rule is that a devisee must survive the testator to take under the testator's will, which is to say that the law imposes a default condition of survivorship. If the devisee does not survive the testator, the gift is said to lapse. If the devisee is already dead at the time the will is executed, the gift is considered void. The text states the common law rules regarding lapsed and void devises. And what happens to these devises depends on whether the gift is a specific, a residuary gift, or a class gift, whether an anti-lapse statute applies, and whether or not the no residue of residue law is in effect. Let's quickly go through some definitions. These classifications of testamentary gifts are important not only for lapse and void gifts, but also for issues of satisfaction and abatement. A specific devise is a gift of a particular item of property that's distinct from all other objects in the testator's estate. The issue in determining whether a gift is specific is whether the testator intended the beneficiary to have one particular thing and that thing only. A general devise, on the other hand, is a gift that's often a dollar amount that's payable out of the general assets of the estate, and it doesn't require a particular source for the payment. The residuary estate is the residue, or consists of the balance of the testator's property after the estate has paid for debts, expenses, taxes, and any specific or general gifts. And although I didn't include it on this slide, a class gift is a gift to a group of persons, like children, for example. What happens to the gift to the person who has predeceased the testator depends on what type of gift it is. If it is a specific or a general devise, then the devise will go back into the residue. If it is a residuary devise, if the residuary devise lapses, the heirs of the testator take by intestacy. If only a share lapses, then there is the no residue of a residue rule. For class gifts, surviving members of the class divide the gift. For a void devise, if the devisee is already dead or otherwise an ineligible taker, the devise is void, and the common law rules of lapse apply. I want to talk a little bit about the no residue of a residue rule. Suppose that a testator devises her residuary estate to 2 or more beneficiaries, and one of those beneficiaries predeceases the testators, and that state does not have an anti-lapse statute. At common law, and in some states today, the share devised to that beneficiary does not pass down to the remaining beneficiaries. Instead, the lapsed residuary gift falls out of the will completely and passes through intestate. And this was called the no residue of a residue rule. So in the example on the slide, if T devises the entire state 1/2 to A and 1/2 to B, and B dies before T or is a dog, and T dies, then what happens to B's share? Well, in the common law rule, or the no residue of a residue rule, A would receive only 1/2 of the testator's estate, and the other half would pass by intestacy to the testator's heirs. Under the UPC, however, this no residue of a residue rule has been done away with, and in a situation like this, A would just receive the entirety of T's estate rather than it going to intestacy. Lapsed gifts versus anti-lapse statutes. If a will beneficiary dies during the testator's lifetime, as we discussed previously, then the gift to him will lapse. It will fail, because a will cannot make a gift to a dead person. However, most states have what are called anti-lapse statutes. Anti-lapse statutes operate to save the gift, but it usually only applies when 2 elements are met. And that is, the predeceased beneficiary was within a specified degree of relationship to the testator, and that beneficiary had descendants who survived the testator. The UPC specifies that the beneficiary needs to either be a grandparent or a lineal descendant of a grandparent of the testator. This is the degree of relationship required by the UPC. It also requires that the issue of the deceased devisee survive by 120 hours. So that is the anti-lapse version that is found in the UPC. The purpose of case 4 on page 358 is to illustrate and to give you a little bit of background and understanding why there is the relationship requirement and the presumed intent behind the anti-lapse statute. The idea is that for certain devisees, the testator would probably have preferred that the devisee's descendants take the gift than for the gift to lapse. So in this case, where T devises the entire estate, one half to A and one half to B, and B dies before T, leaving a child to C, then T dies, what would happen to B's share? Well, in common law, remember, B's share would lapse and pass by intestacy. But without this no residue of residue rule, B's shares of the residue would go to A, and A gets the entire estate. Now, if we add in an anti-lapse statute here, then C would take B's share. So going over that once again, the residue by residue clause in this situation, the residue by no residue of the residue rule would affect the outcome, because B, who predeceased T, their share would pass through intestacy without the no residue of residue rule, however, but without the anti-lapse statute, then B's share of the residue would go to A, and A would get the entire estate. However, with the applicable anti-lapse statute, C would take B's share. The idea is that the testator, it's presumed the testator would have preferred that B's heirs would take, rather than the share go to intestacy or all to A. Unless, of course, the will states otherwise. But why does the anti-lapse statute only apply to family members of a certain degree as opposed to spouses or in-laws or friends? Well, it's debatable whether the testator would want the children of a predeceasing spouse, their stepchildren, or children of a relative of a spouse, or children of their friend to take a lapse divide. In case 5 on page 358, if we were to change the facts so that T devises their home to their niece, B, and the residue to A, and P predeceases T, leaving a child, C, who survives T, what would happen to A's share? Under the UPC, under the anti-lapse statute, C would take T's home because B is a descendant of T's grandparent. C falls within the required relationship of the anti-lapse statute. Therefore, C would take the home. Now, for some anti-lapse statutes, the statute would only apply to T's descendants and not to descendants of the parent or the grandparent. And in one of those situations in which the anti-lapse statute only applies to T's descendants, then you could see the anti-lapse statute would not be applicable. The devise would lapse and the house would fall into the residue and go to A. Now, it's important to remember that the anti-lapse rules are just default rules. So if we have evidence that the testator's actual intent was different than what is presumed by the statute, then the statute will yield to that intent. So again, remember, it's merely a default rule. In this case, case 6 on page 359 illustrates that it's a default rule. In this case, T divises the entire estate 1/2 to B and 1/2 to A. But if A or B or both do not survive me, then I give such predeceasing child share to my friend F. B dies before T, leaving a child C. T dies. What happened to B's share? Well, an anti-lapse statute states the default rule, but because the testator here has provided expressly for the possibility of B predeceasing T, the anti-lapse statute does not apply, and F receives 1/2 of the estate. Not only does the anti-lapse statute not apply if there are contradictory, if there's a demonstrated contradictory intent in the will by the testator, but it also may not apply if there are words of survivorship. And here we have a difference between the majority rule and the UPC. So in this case, T devises Blackacre to my son Sidney if he survives me, with the residue to his wife Wilma. Sidney dies before the testator, leaving a daughter, Debbie. Testator dies. Who takes Blackacre? The question centers around this words of survivorship, if he survives me. And the issue is, do the words "if he survived me" evidence an intention that Sidney's decedents should not be substituted for Sidney? Well, if the state has adopted the majority rule, then an express requirement of survivorship, such as "if he survives me," would be evidence of an intention that the testator demonstrated that Sidney's descendants should not be substituted for Sidney, and Wilma would take Blackacre. So the words of survivorship would be enough to make it so that the anti-lapse statute does not apply. However, under the UPC, the term "if he survives me" is not sufficient expression of a contrary intent from the anti-lapse statute, and so the anti-lapse statute would apply, and Debbie would take Blackacre. A class gift is a disposition to beneficiaries who take as members of a group. Taking as members of a group means that the identities and shares of the beneficiaries are subject to fluctuation. A disposition is presumed to create a class gift if the terms of the disposition identify the beneficiaries only by a term of relationship or other group label. But that presumption is rebutted if the language or circumstances establish that the testator or transferor intended that the identities and shares of the beneficiaries to be fixed. So the main things to remember about the definition for class gifts is that you have a class gift if the members take as a group, and that their identities and shares are subject to changing depending on who is in the group. Now, this presumption can change if the language in the will suggests otherwise, or if the identities or the shares of the beneficiaries are fixed. If they are, then you do not have a class gift. Now, understanding a difference between a class gift and other types of gifts is important because the anti-lapse statute may apply in a different way than it would otherwise. So here again, it states that if the identities and shares of the beneficiaries are fixed, the disposition does not create a class gift. And the following rules are rules that would apply. They apply in helping you determine whether or not the names and identities and shares of the beneficiaries are fixed. And these rules are, if the terms of a disposition expressly fix the identities and shares of the beneficiaries, then clearly they are fixed. If the terms of the disposition identify the beneficiaries by their names or by a relationship or other group label and either by name or number, the disposition is presumed to be to beneficiaries whose identities and shares are fixed. So if names are used to define the group, then you may have a fixed situation where membership is fixed and you don't have a class gift. But this presumption can be rebutted if the language or circumstances establish that the transfer intended the beneficiaries to take as members of a group or a class. Let's take a look at case 10, which can be found on page 372 of your book. Here we have a testator, T, whose husband and sister C predecease her. T executes a will, giving Blackacre to my sisters and residue to stepson S. Then sister A dies. Then the testator passes away. Question is, who gets what? Well, first we must decide if to my sisters is a class gift. It does not list names. My sisters is a group, and it does not list names, nor does it specify the share amounts to each, so it would fall under a class gift. Now, the class gift rule says that if a will makes a gift to a class of persons, like sisters, and a class member dies during the testator's lifetime, those class members who survive the testator take the gift, absent a contrary will provision otherwise. Now, the rationale for the class gift rule is that the testator did not want anyone other than members of the designated class to share in that gift. However, this class gift rule gives way to the anti-lapse statute if the anti-lapse statute applies. So if the predeceasing class member is within the scope of the statute and left decedents who survive the testator, then the anti-lapse statute applies, whether or not the class member's death occurred before or after execution of the will. So if we're applying the UPC rule here, anti-lapse statute rule, then it would apply because the sisters to the testator would fall within the class that the anti-lapse statute applies to, and in which case D and E would take A's share, would share an A's share. B would take a respective third of Blackacre, and F would take the other third. Page 373 has a great diagram that I reproduced here for you. It's a flow chart that can help you decide which rule to apply. So, if A's gift has lapsed, does the anti-lapse statute apply? If the answer is yes, then you distribute it to A's descendants. If the answer is no, you ask, is A's gift part of a class gift? If yes, then you can reallocate among the other class members, even if the anti-lapse statute does not apply. If not, you can ask if the lapsed devise is specific, general, or a residuary. So if it's a specific or general devise, then it would fall into the residue. And if it's the residuary, you would ask yourself, does the state follow the no residue of a residue rule? If it does, then you would distribute to the heirs by intestacy. But if not, you would distribute to other residuary devisees, or if there are none, then to the heirs by intestacy. So we discussed changes in regards to beneficiaries after a will is executed. But what about changes in the property after the execution of the will? Under the doctrine of ademption, when specifically bequeathed property is not in the testator's estate at death because it was, for example, destroyed or sold or given away or lost, that bequest is deemed. It fails. Ademption applies because the property that was to have satisfied the bequest is no longer owned by the testator at their death. Something to remember about ademption is that it applies only to specific devises, and it does not apply to general devises. Ademption applies only to specific devises and bequests, those that are, as we remember from before, particularly designated. They are specific things that are given to a person. Now, it does not apply to gift of the sale of proceeds. So, for example, let's say that the testator's will provides that they direct, the testator directs the executor to sell Blackacre and distribute the sale of the proceeds to my brother Bill. Well, most courts will hold that ademption doesn't apply here, and that Bill can take the sale of the proceeds to the extent that they can be traced. Because the gift was of the proceeds of the sale, not of the actual of Blackacre. So it does not apply, ademption does not apply in such circumstances. Partial ademption applies when the testator devises, for example, a large tract of land and then sells a portion of that tract of land. Ademption would apply to the portion of the property not in the estate, but the remaining portion in the estate at the time of death would pass to the beneficiary. Special rules apply to bequests of securities. Courts construe bequests of securities as a general devise, if possible, in order to avoid the application of the ademption doctrine. So the case will turn on whether the testator made a gift of, quote, 200 shares, let's say, versus my 200 shares. Well, let me give you an example. So let's say Tom's will bequeaths 200 shares of Apple's common stock to his cousin Bill. Afterwards, Tom then sold the stock and does not own any such stock at his death. Because the bequest was of my 200 shares, then this is a specific bequest. And ademption would apply here. Now let's look at another hypo. Let's say Tom's will bequeath 200 shares of Apple stock to his niece Nora. Then Tom sells the stock and does not own any Apple stock at his death. Here, the courts would likely seize on the absence of the possessive pronoun my, and would conclude that Tom didn't intend to make a specific gift of the shares. Instead, Tom made a general devise. And here, ademption wouldn't apply because, if you remember, ademption doesn't apply to general devises. A little bit about testator's intent. Under the majority view, whether or not ademption applies does not depend on testator's intent. Most courts apply what's called the identity theory of the common law, under which the ademption issue is decided solely on an objective test. And that test is whether the specific devise is part of the testator's estate at death. Under this approach, the testator's intent is irrelevant. Courts don't speculate on why the property is no longer there, just that it is no longer there. Most states have enacted statutes that soften this ademption rule in certain circumstances, and the UPC is included. But for our purposes, we're not going to worry about these distinctions or differences. Accession refers to increases to a property after the execution of a will. Now, that increase to property can occur after the execution of a will, but before the testator's death. So, for example, increases to specific gifts that occurred during the testator's lifetime, they would be distributed as follows. Say rents and profits from property would go into the general estate, but improvements to real property go to the specific devise. If increases occur after the testator's death, any increase to the specific gifts would pass to the specific beneficiary, which makes sense because the beneficiary is deemed to be the owner of the property from the time of the testator's death. So any increases would go to the testator's beneficiary of the specific devise. For some reason, stock splits and stock dividends have been tested on the bar exam, so they're worth discussing. Like common law, specific devises of common stock was entitled to additional shares of that stock that were obtained by the testator as a result of the stock split, but not if additional shares were acquired as a stock dividend. The modern rule under the UPC and nearly all states treat stock splits and stock dividends the same way, and they pass to the specific devisee. I'm going to give you a couple examples. Let's say the testator bequeaths 500 shares, my 500 shares of Southwest Airlines stocks to my daughter, Carol. And after that, Southwest declares a 20% stock dividend. And so as a result of that, a stock certificate for an additional 100 shares is issued to the testator. After that, Southwest declares a 2-for-1 stock split, and an additional 600 shares are awarded to the testator. So on the testator's death, Carol takes 1,200 shares of Southwest stock under the testator's will, even though the will only stated that Carol would get my 500 shares of Southwest Airlines stocks. Now let's say we have the same facts, except that the testator's will bequeathed 500 shares, not my 500 shares. There's a pesky my or lack of word my again. Then Southwest declares a 20% stock dividend and then a 2-for-1 stock split. Despite the absence of a possessive pronoun, this was still a specific bequest of Southwest stock, and Carol would take the additional 600 shares produced by the stock split. I know this is confusing, but a bequest of stock could be classified as general for one purposes, ademption, and specific for other purposes, the stock split. So just remember that when it comes to increases in property and stock splits and stock dividends, it doesn't matter whether it says my shares or just 200 shares. Lastly, we are going to discuss the topic of abatement. Abatement is the process of reducing a testamentary gift in cases when the estate does not have enough assets to pay off all claims by creditors, and then to also pay for satisfy the bequests and devises. So the testator can set out an order of abatement in the will. So the testator can say, here is the order in which I want the assets to be used to pay off debts. If there is no statement in the will, most jurisdictions will abate in the following order, meaning they will go into these assets first to pay for claims of creditors. They'll start by property that passes through intestacy. And if all of those assets are still not enough to pay the claims by creditors, they will go into the residuary estate. If those are not enough, they will go into general legacies or general devises. After that, they will go into specific devises and bequests. That concludes the material for wills, for Chapter 5 and for wills.